Welcome back to the video lecture on East Asian states' leadership in international law. This time, we are going to looking at the preemptive strikes under international law, looking at the three states examples to use this term. The first, we are going to touch upon the Putin's preemptive move. The interpretation and determination of the military terminology under international law is extremely fluid, depending on the context and subject and outcome. It is also highly probable that the legal evaluation will vary depending on the outcome of the act. The military terminology is also commonly used as a defensive measure against subsequent legal evaluations. In his Victory Day speech, marking the 77th anniversary of Soviet Union's victory over Nazi Germany, on May 9th, the Russian President Vladimir Putin claimed that Russia's military action in Ukraine was a timely and necessary response as a preemptive move to ward off aggression from the West. Putin used the term preemptive move to protest the criticism regarding the illegality of warfare that has led to a calamitous destruction. However, there is no evidence of the Western aggression to support Putin's sophistry. The North Korean nuclear and missile threats are an omnipresent source of instability, undermining Korea's national security. During the South Korean presidential elections, the word of the candidate caused a lot of controversy. In particular, preemptive strike, the term that was being along with the kill chain and the 3-axis defense system, also raised the issue of its legality under international law. The legality and illegality of preemptive strikes under international law were clearly distinguished according to factional rhetoric. The kill chain is a portmanteau of kill, the meaning decimation or elimination, and chain meaning rotating chain. Literally, it referred to a series of strike systems to neutralize the target. Since the late 1990s, the South Korea has been preparing the Korean missile defense system in response to North Korean missile attacks. In 2016, the Korean massive punishment and retaliation strategy was proposed as a response to the 6th North Korean nuclear test. The South Korean 3-axis system was established as a strategy to counter the North Korean nuclear program, combining kill chain, KAMD, and KMPR. The Moon Jae-in administration referred to this 3-axis system as the nuclear weapons of mass destruction response system, so as not to provoke North Korea. In announcing his vision and pledges in diplomacy and security during his candidacy, the President Yoon Suk-yeol said he would catalyze the establishment of the South Korean 3-axis system, including kill chain, for the protection of the lives and safety of South Korean people. In the context of the military and security, the use of military terms does not pose any problems. Rather, the controversy lies in President candidate Yoon Suk-yeol's use of the term preemptive strike, along with the 3-axis system. After candidate Yoon's use of the term, the divergent understanding of the same terminology on the part of the military security and international relations academia and international law academia sparked confusion. The pledge of the book of the People's Power Party that proposed the securing the rights of self-defense through kill chain, reinforcing KMD and KMPR in relation to the restoration of the South Korean 3-axis system and bolstering of the countermeasures to nuclear weapons and missiles. Moreover, it proposed the specific means through which the right of the self-defense, the via kill chain, may be secured, namely by securing strong preemptive strike capabilities such as high power, super precision, and supersonic speed. During the election process, the Democratic Party of Korea criticized candidates of the Yoon for using the term of the kill chain synonymously with the term preemptive strike. With regard to his analysis of the preemptive move, candidate Yoon was faced with criticism for his allegedly belligerent strategy, which was followed by the libertors and libertors from the People's Party. And however, the kill chain is but one of the various military operations removing targets that pose the imminent threats and is one of the many means of the preemptive strikes. Indeed, it is an act of the defense that protects the state by preemptively removing the target when the enemy clearly intends to inflict damages on its people and territory. Neither kill chain, a term synonymous with the preemptive strikes. The ambiguous distinction between preemptive strike and preventive strike by those who mention preemptive strike has raised misunderstandings. Domestic Military Security and International Relations Academia defined the preemptive strike as an act of anticipatorily removing the threat of armed attack where such an attack has not actually occurred but is imminent. On the other hand, a preemptive strike referred to a preemptive move taken to eliminate a potential threat that is not imminent as of present, but one that may become a real threat in the future. Nevertheless, domestic international academia use the term preventing strike in a sense that military security and international relations academia use preemptive strike and vice versa. Considering that the concept and terms apply to facts and the legal liability should be consistent, the defense or different concepts in academia should be aligned. At present, it seems the understanding of the security and international relations academia is comparatively more accurate under the facts. A preventive strike is an act of war. Therefore, it cannot be justified under international law. On the contrary, as it relates to preemptive strikes, considering that the countermeasures of state under attack by weapons of mass destruction, for example nuclear weapons, are substantially lost given the very nature of the modern warfare, there is a possibility that preemptive strikes may be recognized within a limited scope and under the very strict requirement in a sense that it guarantees the ex post right of the self-defense. Even so, it is clear that the preemptive strikes likewise constitute an act of the war that preemptively undermines the peace despite the controversy over its scope of recognition under international law. Let me touch upon the North Korean issues. During the 90th anniversary of the founding of the Korean People's Revolutionary Army on April 25, the North Korean Supreme Leader Kim Jong-un, in referring to use of the nuclear weapons, said that if necessary, preemptive measures shall be taken to thoroughly subdue and suppress any and all dangerous attempts and threats, including nuclear threat by adversaries, and that the absolute superiority of the revolutionary armed forces must be firmly maintained and continuously revamped. Hence, the political leaders of both South Korea and North Korea have used the term preemptive strike as it relates to military security. Then, what are the respective meaning of preemptive move advocated by Putin of Russia and the preemptive strikes mentioned by then-President candidate Yoon Suk-yeol of Korea, and finally, preemptive substitute and suppression emphasized by the North Korean Supreme Leader Kim Jong-un. The right of the self-defense is recognized under international law as a unique rights of each state that serve as a measure of self-help under which a state can take any countermeasures necessary to preserve its territory or political independence in response to an external armed attack. Likewise, the UN Charter recognizes rights of self-defense as an exception to the prohibition against use of force. However, the exercising rights of the self-defense is strictly limited depending on its purpose. According to the customary international law established through the various precedents, the use of force for the purpose of exercising right of self-defense is subject to stringent requirements such as necessity, proportionality, immediacy, and minimize of the damages. That is, the right of self-defense should be exercised only where there is no alternative other than military responses in order to repel the armed attack. Within a scope proportional to the goal of repelling an armed attack, immediately in response to an armed attack or following the armed attack, and cannot be exercised after the armed attack ceases, and toward the legitimate the military targets, thereby minimizing indiscriminate damage to civilians. It is clear that Russian invasion of Ukraine that launched on ongoing warfare is not only a brutal war crime, but also an illegal act contravening the exercise of the self-defense recognized by the international law. Furthermore, it is difficult to say the Putin's military actions satisfy the stringent requirements applied when invoking the use of force as a measure of self-defense, namely necessity, proportionality, immediacy, and the minimization of damages. Neither is aggression from the West the Putin's alleged prerequisite for his preemptive move to present. Given that the term preemptive strikes was invoked by the President candidate Yoon Suk-yeol as a specific means to secure the rights of the self-defense through kill chain, it should be exercised only under circumstances where conditions justifying the act of war are deemed mature to invoke such a right. It is a matter that should be stringently consistent with the basic norms of the principle prohibiting the use of force in international law. Finally, the term preemptive substitute and suppression emphasized in North Korean Supreme Leader Kim Jong-un are susceptible to being misemployed since it appeared that the term was used in consideration of the preemptive strikes as a countermeasure in a sense more comprehensive than the usurpation of the North Korea's fundamental interest. Thank you very much for your very kind attention.